Welcome. The Stand Your Ground doctrine, which has been acted in 24 states, is also something that you can see in other states in a different form, one of them being California. My guest is retired Superior Court Judge of Santa Clara, California, Eugene Hyman. In this particular case, in the Trayvon Martin case with George Zimmerman as the defendant, there is a pretrial process to see if there is enough evidence in Florida, right?
Correct.
Can you talk about how likely you think the judge is to grant the pretrial motion to dismiss, which is based upon Stand Your Ground, which has some criteria that have to be met?
Correct. First of all, it's a very low standard, which is a preponderance standard, which is more likely than not slightly more than 50%, anything more than 50%. So while from an evidentiary standpoint, it's very low, and it's a pretrial mechanism to eliminate the possibility of going to trial where someone asserts and a judge agrees that that was the reason for the homicide or for the murder or for the killing. It's still one still needs to deal with the political realities of the situation. Number one, in Florida, judges at the trial court level are elected. So the reality is that puts pressure on judges. This is a very high-profile case internationally. So that's number one. Number two is the fact that in the event that a judge denies it, number one, there's the possibility of a pre-jury trial or court trial appeal to the appellate courts to decide whether or not the trial judge made the right decision. And secondly, the defendant, in this case Zimmerman, gets a second opportunity to demonstrate that he was acting in self-defense in front of a jury. So it isn't like if the judge denies the pretrial motion that ends the defendant's opportunity to prove self-defense. It's just that it places the burden on him once the people demonstrate a prima facie case, then the burden shifts to him to prove that it was self-defense.
So in this particular case, there isn't a whole lot of physical evidence. There's simply a lot of circumstantial evidence. Does this affect the pretrial process at all? I mean, it seems like it makes it more difficult for this to go forward.
Well, the problem that you have from the defendant's position is that there's various degrees of media attention to this in terms of what Mr. Zimmerman's injuries were, to what level that he had injuries. Remember, even Stand Your Ground, the amount of force that you use to protect yourself, your property, has to be reasonable under the circumstances. When you have a defendant who is alleging that in fact he was the victim, not the person that he killed, then you need to demonstrate substantial injuries. And no matter what version of the media report you read, it doesn't look to me like Mr. Zimmerman had any substantial injuries, in which case then it suggests that the amount of force that was used that culminated in a killing is suspect for reasonableness, in which case let a jury decide. So
what you're saying then is after the pretrial process, then the burden to prove self-defense moves over to the defendant.
Right, which is sort of an interesting dichotomy, because the general rule in any criminal case is that the people have the burden to prove their case if they can beyond a reasonable doubt. So the people have to go first, since they have the burden of proof. They demonstrate that Mr. Zimmerman had a gun, that the alleged victim didn't, that Mr. Zimmerman killed someone. It's going to suggest a lack of injuries on the part of Mr. Zimmerman. So then the question is, did the people, in fact, demonstrate a prima facie case? That is, did they prove initially the elements of the crime? And if so, then the burden shifts to Mr. Zimmerman to prove that the killing was in self-defense.
So talk about the difference between second-degree murder and manslaughter, and in the trial process after the people rest. They're going to move for some sort of acquittal. What's going to happen then?
Well, I can just about guarantee you, based upon experience and based upon case law, and given the media reports in this particular case, that once the people rest, then Mr. Zimmerman's attorneys are going to urge the court to grant what's called a motion of acquittal. That is, the trial judge would have to decide that the prosecution had not presented a prima facie case of proving all of the elements, and that no reasonable jury could return a verdict of guilty. In which case, then, if a trial judge grants that motion, that ends the case entirely. However, the trial judge in a case where second-degree murder is alleged could make a finding that the malice element, which requires a certain mental state, has not been proven, and that granted as to the second degree, but still feel that the people had made a prima facie case with respect to manslaughter, and allow that to go to the jury. In which case, then a jury would decide whether or not whether or not the manslaughter was proved beyond a reasonable doubt, or the judge could deny the motion, in which case a jury would decide, because a court is required to instruct on lessers that are included. In other words, manslaughter is a lesser-related charge to second-degree murder.
Right.
So a jury could decide that second-degree murder had not been proven beyond a reasonable doubt, but that manslaughter had, and they have that power, or any trier of fact, whether it be a judge trying the case or a jury trying the case, could make that decision. I think it's more likely that a judge might decide at that particular point that the more serious charge had not been proven, and let the jury decide on the manslaughter.
Right.
Then I think it's likely that a judge will knock out the entire thing and say that nothing has been proved prima facie up at that particular point, and taking that one more extreme, having a judge knock it out at a pretrial level. I'm unaware of any studies, I'm sure there's been one, but I'm unaware of any studies that since the stand your ground law was passed in Florida, how many times has it been raised at a pretrial and how many times has it been granted. I'm willing to venture that while it may have been raised a great deal, I bet you it's been rarely granted.
All right. Well, it's very interesting. We will, of course, keep following this like everybody else. And Judge Hyman, we appreciate your expertise in this area.
Thank you very much.
And you're watching the Family Law Channel, an affiliate of the Legal Broadcast Network.